Hello, everyone. Welcome to the Future of Laws Today, the podcast bringing you straight talk on law, legal tech, and where the profession is going. I'm your host, Cheskino, and we're cutting through the hype to talk about what's changing in this field and what still needs to. Today's guest is Ali Mohammed, founder and CEO of Jurist AI, a company using artificial intelligence to make the justice system fairer, more transparent, and more accessible. Ali's professional background bridges law, ethics, and engineering. Before launching Jurist AI, he worked as a solutions architect and systems engineer, building blockchain and cloud infrastructure. But his commitment to justice reform started long before that. When he was 20 years old, Ali began volunteering across multiple initiatives, most notably as an intern at a federal criminal defense firm, doing public cases with the U.S. Department of Justice. That same sense of purpose runs through Jurist AI's mission today, to level the playing field in the justice system, starting with tools for federal defense attorneys and small business founders. Ali's vision for legal tech is deeply human-centered, designed for the least resourced person in the room, build transparency into every algorithm, and treat AI not as a replacement for people, but as a way to empower them. Ali, great to have you on the podcast. So, can you tell us a little bit about your background? How did you get into legal tech?
Yeah, definitely. And thanks for having me on. So, my initial exposure to the law was when I was in college. I've always had kind of a humanities bent, but growing up in the DC area at the time, I got pushed into STEM. So, I ended up doing my master's degree in IT management, ended up becoming a software engineer. But when I was in college, I actually interned helping a federal criminal justice firm with public criminal defense. So that experience really stuck with me, seeing some of the inefficiencies and the failures of the justice system. So when ChatGPT got big, I thought, oh, wow, this is going to be so transformative for access to justice. But when it wasn't, I was pretty disappointed. So I thought, you know what? I have quite a bit of money saved up. Why don't I go ahead and just dip my foot into this? I had something very specific in my mind, which was automating a lot of the stuff that is very rote specifically for criminal justice. I met my co-founder and he was like, wow, Ali, this is great, but there's not a lot of money in criminal defense. So that's how we got into civil litigation. And that's where we are right now.
Okay, fantastic. So you and I have had some conversations around legal tech and making sure that you're serving your customers, your end users, your buyers, and solving problems for them rather than just creating a solution that's looking for a problem. So people talk about meeting customers where they are, but how do you incorporate that mindset into product development?
Yeah, that's a really interesting question because it's something that we've grappled with dealing with clients hands-on. So initially, we invested a lot in developing a very smooth interface, very clean user experience on our web app, and it was great. But what we started noticing was we would demo the product, firms would love it, they'd sign up, they'd pay for it, and then they would never log in. So that was concerning to us because they're paying for the product to make their lives easier. But if they feel like, oh, going onto another portal and learning how to navigate a new user interface is something that is a hurdle for them, or almost like they have to upskill, even if we think the platform is really easy to use, we're looking at it day in and day out. We're not an attorney that is swamped with work, has deadlines, is trying to manage clients. So one of the first steps that we took was, look, let's just add some redundancy and let's email all of the work outputs, all the work products, the drafts directly to the user, so that sometimes it takes a couple of minutes to produce a draft, or it takes a little bit of time. They don't have to sit there and wait. They can go continue working and have it in their inbox. We noticed that users really like that, and they started depending on the email updates more than actually going into the platform and manually triggering stuff. So then we had the idea, well, what if the user could do everything they could do on our platform in terms of research, in terms of drafting, in terms of creating interrogatories or checking their docket or analyzing their opponent briefs? What if they could do all of that from the email, almost like they were instructing an associate or paralegal to go out and complete a task for them? So it took us some time to figure out how to do that. but we opened up the email interface about a month ago. And our clients really, really like that because the software is proactive. So it'll let them know when there's a docket update and draft a response brief. But then they can go and respond in thread and say, hey, look, this part of your response brief, I need you to change this paragraph. Or they can say, hey, can you research this issue? And all they have to do is email the agent and let it know what case they're working on. And it will go and figure out, okay, I have all these internal APIs that I can call. This is their request. This is the case. This is the user. I need to find the right context and then send it to them. So it's a very seamless experience where attorneys use email all the time, right? That's the first thing that they're going to check in the morning. So being able to collaborate with the agent over email and get polished, formatted drafts that are jurisdiction specific, practice area specific, with actual citations in there, or do research or analyze something, being able to do it right from email just integrates pretty seamlessly to what they're already doing.
Yeah, that's fantastic. I like how you're really thinking outside the box because for a long time now, a lot of these software solutions, B2B SaaS, have been cloud-based. There's this idea that people should log into your platform from wherever they are. That's what people want. But when you're selling these solutions, as you pointed out, that's not always the case. Sometimes people don't want to log into yet another software application. If that's what they want, that's great. But what you did instead was met people where they were. And as you pointed out, like it or not, lawyers still use email extensively. I think there's more and more of this realization that instead of trying to force people to adapt how they work and where they work, it's better to plug into the things they already use. So Microsoft Word, Outlook, wherever they already are, make it as frictionless as possible for people to adopt what you're selling.
Exactly. Yeah. Especially with attorneys, right? There's an adage that drill companies, or I think Black & Decker is one of them, they're not selling drills, they're selling holes. What you need is the right hole for what it is that you're building. And attorneys need drafts or research. They need that work product output. They don't really care, and in fact would prefer never to have to deal with some other user interface or some other platform or some additional complexity that you're adding. Us as nerds, we love that. We love tinkering around with new interfaces, and we love going back and forth between Figma and designers and making something that looks really cool. But the reality is exactly like you said. Attorneys, their bread and butter happens over phone call, happens over text, happens in Word, and it happens over email. And the more that fluff that you add to that is just more of a distraction from how they actually do their practice.
Yeah. Well said. It might sound like sacrilege to some people in the software world, but yeah, if you're adding additional steps, if you're taking people out of their workplaces, their workflows, to them at least, it's going to feel like fluff. You do want to make sure that you're cognizant of how people work, how they prefer to work. And I think that there's a perception among some people that, oh, these people are stuck in their ways, but it's not really that. If you have something that works, what's the point of breaking it? Unless it's being replaced with something that is tangibly, recognizably better. And if you're not providing something that is definitely better, then yeah, better to integrate.
Yeah, I think some of the disconnect comes from misidentifying what attorneys are like. You try to classify attorneys as if they're business people, but really most attorneys are more like artisans. They have a craft, they are very knowledgeable, they have years of experience, and they know how to produce a really high quality output that is specialized to the specific use case. So if you go to a craftsman and you try to give him a tool, which is actually less accurate than his current tool, but looks a lot cooler and has a lot of extraneous features, I'm going to say, no, you know what? The hammer and the chisel, they work just fine for me. I don't need your super duper tool. And I think that's what the legal tech community is starting to realize, is that we have a lot of these really cool fangled tools, but the two components are missing. Number one, accuracy is a huge problem. And then number two, trying to force these artisans, these craftsmen who have developed a very specific way to produce something that is really high quality, trying to get them to change doesn't make sense then. And it doesn't make sense at all because their output is defined by the series of steps that they've been doing for 5, 10, 15, 20 years. So it's better to find that craftsman and give him a much better hammer and chisel than to try to reinvent the wheel. AI makes it really tempting to make people think, oh, well, we can just do everything in this totally different way. But the reality is that you're trying to change the fabric of something that does work instead of assisting the people that are creating that great output.
Yeah, I really like that analogy. You do hear lawyers refer to it as a craft. It's not just an output in terms of we need to produce this many documents. That might be how people paying for legal work sometimes think of it, like, oh, you just produce briefs, you just produce memos and contracts. But no, there is more to it than that. And lawyers, certainly those who enjoy their jobs, they pride themselves on the craft and the analysis behind it. And this is something I've been talking about with people, that there's a fundamental cultural disconnect between many legal tech vendors and legal practitioners. But it sounds like you've really done the work of talking with lawyers and trying to understand, well, how do you as a lawyer view your profession, or as you put it, your craft? Because it's not how I, as a person with 10 years of sales experience or 20 years of marketing experience or whatever it might be, 15 years of engineering experience, it's not how I view it. It's how you as a lawyer view it. That's how you know what to build and how to talk about what you've built.
Exactly. And that insight is not mine alone. I can't take the credit for it. We have attorneys at Jurist AI, especially my co-founder, Mark Underwood, who's a veteran attorney of 30 years. So I had some exposure to the legal world, but most of my experience is in software and architecture, software architecture. So for me to gain that understanding, gain that insight, took a lot of interacting with customers and also just going back and forth with Mark, especially as we collaboratively developed the software. So we work together and I see how Mark works and I see what particularities or peculiarities or idiosyncrasies he finds important versus what the clients find important. And that led me to realize, okay, these people take a lot of pride in what they're doing. And so if we're trying to seamlessly, along with them, flow into what they're doing and make it more efficient, it can't be to replace them with what I think is better. It has to be in their style, in the way that they're used to working, but as additional support so that they can focus their craft on the areas that they really like. Nobody likes formatting. Nobody likes spending a lot of time formatting documents. There's a lot of motion practice, which is very rote. But there's some aspects of litigation which require a lot of special attention, which require specialized research, which require a lawyer's specific voice. And sometimes there's no exact algorithmic answer. There are controversies in law that are unsolved every day. And that's what you want to enable lawyers to do. You want them really focusing on the higher, more sophisticated aspect of their craft. And hey, look, we'll just help you out with some of the other skeletal work that you don't mind being automated so that you can do what you really excel at. So it's not so much about replacing lawyers or telling lawyers about how to do their job. It's more, hey, let me free you up so that that really special, unique part of almost creating the law, which is what happens a lot of times in court, you can do that.
Yeah, there's fantastic insights. And I like that you highlighted you're not just pulling these out of the ether. And it's not even just about interviewing customers, although, of course, looking at how your customers actually use the platform is part of it. You do have, as you said, a co-founder who spent 30 years practicing law, and having that insight, that direct insight into how this experienced attorney works and processes information and actually wants to use the tools or does not want to use them. That's a key part of developing your platform. So that actually is a perfect segue into my next question. Have you found that your first instinct is usually the best one when it comes to identifying new features to develop and anticipating how customers will use them?
No, definitely not. Your first instinct, especially me just being a software nerd, my gut instinct is always how do we automate this, make this more efficient, standardize it, and let people do it at bulk so that they can take on another 5, 10, 15, 20 cases. So I'm thinking about it in a very modularized, technical, and business fashion. So my gut instinct is always, okay, what's the best way to make this super efficient so that everything is standardized and you can produce this en masse. And then that way you can go and get another 5, 10 cases and everything will just look the same and you can do it super fast. But that's not a good gut instinct at all. And I think a lot of legal tech founders kind of suffer from the same thing. And it doesn't really speak to how law works. or how lawyers would expect a tool to work. Our vision now is really to build a robot paralegal, a proactive piece of software that will go out and do work and send it to you over your email that you can go back and forth with and correspond the way that you'd expect a human to, but that can do work a lot faster and that can do work that's extremely accurate. And that's very, very different than trying to develop a cookie cutter form approach or just selling a raw LLM model that's supposed to be for legal to lawyers with some front end changes on top. But when it comes to building features, there's also the conundrum of sometimes users don't know what they exactly want or what they need in software. So they might have an idea of what would work best for them and they may suggest that. But until the user actually has a feature in hand, you can't tell whether they'll actually find it useful. You can't tell whether they'll interact with it. Or it could be that a feature is totally useless until you make some small change and now it's amazing. So that's another component. So it requires a lot of patient customers and a lot of patient development as well.
Yeah. What it calls to mind for me is in business school, they teach you don't just go and develop some new product in a silo and expect it to be great. Develop the MVP, the minimum viable product. What are the key things that people need, or at least that based on your understanding, people in the field you're trying to reach that they actually need, and then go out and test it. Put it in their hands, see how it works, how it breaks, and you iterate on it from there. So fantastic to hear that that's been the approach and that it sounds like that's working really well for you.
Yeah, it's definitely an uphill battle, especially on the MVP component, because what is minimally viable in law is not the same as other areas. Law is really sensitive, and sometimes people's lives hang in the balance. So developing something that is minimally viable just to get feedback on it, you're going to get eviscerated by lawyers. You'll probably get eviscerated even if the product is way beyond MVP and is still pretty good. Lawyers are really difficult to sell to, and it's understandable why. If they weren't really good at nitpicking and finding flaws and tearing things apart, then they'd be pretty bad at their jobs. But it means that as a vendor or as someone that's trying to market to them, you often are on the opposite side of that, which has its cons. But one of the pros that it has is that it's like a whetstone. They will keep finding every possible gap or error or flaw or inefficiency or way that it's not helpful until you really hone it down and you sculpt all that away and you get something that directly addresses what they need.
And that raises another great point, which is if you're building something, you can't be afraid of constructive feedback. It might sound negative, especially given, as you said, lawyers are expert critics. It might sound negative, but it really does help you build something better in the long run.
Yeah, exactly.
Yeah, that segues into my next question really well. So what do you do if customers respond differently than you expected to a new product or a new feature?
Well, you're, as a vendor or as somebody developing legal tech, you're trying to build something that they find useful. So if there's negative feedback, whether constructive or not constructive, you definitely have to humble yourself and you just have to take it. Right? You have to find out openly and honestly, why is this not working for you? And one of the disconnects between developers and lawyers is that a developer will look at a product and say, well, this product got 85% of the way there. It would have taken you 3-4 hours to get 85% of the way there. And then they're expecting the client to be so excited, but they're missing the fact that had the lawyer done it manually, they would be more familiar with their case. There's certain ways that they like to build their arguments. There's just a lot of nuances that are missed. So 85% to a lawyer is trash, is garbage, because the hard part is that last 15% anyways. So when you're building software for attorneys, getting to that 85% point is really, really hard. But having that last 15% of accuracy is really where the entire game is. Because once you bridge that, then it finally becomes a useful tool for them that they can rely on. And lawyers are juggling things like professional responsibility, ethics. They're concerned about whether you are responsibly handling their data. So for them, a new tool is not something fun to just experiment with. And hey, maybe it works, maybe it doesn't, maybe it helps me a little bit. It's a liability. So if they're going to take on that risk and liability into their practice, it really needs to be something that maybe is not a paradigmatic shift, but that makes enough sense for them to possibly expose themselves, even if you try to reduce it, even if you have SOC 2, even if you have, like we do, hallucination detection. For them to have that ease of mind, it really needs to produce something that is very compelling.
Yeah, a couple of really important things you raised there. One is that, as you said, it's a completely different mindset. Whereas if you're an engineer, automating 85% of a task is fantastic. If you're a lawyer, you're looking at that 15% that remains undone. And then the flip side of that is that, as you said, if you didn't do the work and if nobody on your team did the work to produce that first 85%, even if it's faster, you still have to go back and review what was done. Or at least it needs to be presented in a way that, one, it summarizes everything that you need to know in a way that's easy to catch up on, easy to review, easy to share, and two, it's verifiable. Because that's the other thing. If you're a lawyer, you're not just going to trust 85% output, especially when we spent the last couple of years hearing all these horror stories about hallucinated citations and made-up case law and briefs. Nobody can trust that, and you can't blame them for that. We all should know by now that we should be on our guard against hallucinations. So if you want people to adopt the solution, you need to understand that mindset that it's not frivolous and it's not even overly cautious, really. People are getting sanctioned. There's a risk of losing your license or at least compromising your professional reputation if you're submitting one of these briefs with made-up case law in it or whatever the error might be. Again, I can hear where you've done the work of actually talking to people and listening to what they're saying and understanding where they're coming from.
Yeah, hallucination is one of the things that we've taken a lot of pains, because it's exactly like you said. If a lawyer has to go back and manually review that 85% and review it even more carefully than they would ordinarily review something that an associate or a partner or paralegal gave them, because now there's a chance that it can just totally whole cloth make up sites that look accurate, then it just becomes a waste of time. And what's the point? Why would an attorney pay $100, $200, $300, $500 a month for a tool that is wasting their time? So that's why we are very, very careful with respect to sites. We post-process everything that comes out of our system. And if AI has put any sites in there, we just delete them. We use lexical search to go get actual sites. We make sure everything is hyperlinked. And we also have a free site checker now so that people can upload their documents that however they've produced them, go put it in there, check to see if the sites are real. It also reads the opinions and checks the relevancy of the opinions to the arguments that you're making. We're planning to add a quote checker next, where it will check, hey, you've quoted this opinion. Is the quote real? Go back to the original opinion and just try to see if it can control find the quote. And I think that may actually be our most popular feature. Even if users aren't necessarily using our platform to draft or to do research, they'll have their own drafts, or they'll get a draft from someone else in their firm, and they'll use a site checker, and it'll not immediately, it takes about a minute or two. Let you know, hey, yeah, these sites are real. Here's the link to them. This site, I don't know, couldn't find a link for it. You might want to check it out. Here's the relevancy of the sites, and here's a critique of your document. So that may actually be the best thing that we produced so far in terms of customer feedback. I had a lot of pride in all of the automation and the email stuff, but people really seem to like, hey, I send an email to the agent with my draft and it comes back and it lets me know what's solid and what's not.
You touched earlier on that point that from the engineering perspective, there's the excitement of seeing, can we build this? Can we automate these processes that these skilled knowledge workers are doing? But if you want people to buy from you, you need to look at what it is in their jobs that they don't like doing. So you mentioned formatting earlier. That's one thing. Another thing is checking citations. Who likes doing that? I've never heard of anyone who says they like double checking things. They do it because it's necessary, not because it's the part of the job they want to focus on. I think that's worth doubling down on and examining a little closer. That you see some of the commentary out there, and I think some people have just come to accept AI will always hallucinate. There's this idea that the LLMs have plateaued, which I think is probably pretty accurate. But I think the part some people gloss over is that further innovation will therefore have to come from more tailored models, more tailored frameworks, applications built on top of the LLMs. And I think that's the part some people miss. So can you tell us a little bit more about that part? Because you're not, I know this from talking with you earlier, you're not just relying on straight LLM output. How did you build something that can actually verify a citation? And I think the quote checker is maybe even newer. I don't know if we talked about that last time, but
no,
how did you build something that can actually check citations and quotes?
Yeah, the quote checker still isn't out yet. We're still working on that internally, but hopefully in the next couple of weeks, just give you a little preview.
Nice.
There. But
Nice.
The way that we've always looked at LLMs at Jurist AI is that they are really good creative writing engines. And that's it. It's a module that is great at producing mimicry of human argumentation. And that's all you should really use it for. So when we're building systems, the systems at some point, yes, need some creative logic to string things together. But should that really be your entire use case, especially if in our case we're doing litigation or lifecycle or matter management? We don't think so. No. Bringing together multiple kinds of technologies in concert can get you really, really strong outputs. I do think that LLMs are kind of starting to peak in terms of what they can do. And it even seems that as the models become more complex, there's an even higher rate of hallucinations, which makes sense because from their perspective, they're next word predicting. They're trying to look at what's the next best token. And sites look a lot like math. So they just start running computations on sites and they get the wrong output. So it's 100% understandable. So then the question would be, why use just an LLM to do anything in law? I don't think that that makes sense. And we're seeing that even specialized LLMs for law are not performing as well on legal tasks as just generalist models. So we try to use a pretty complex software architecture to do a lot of things. One component is just keeping all of the information that user has about one case in one place so that it's always sent when we have an AI call so that the information is contextual. So that's one piece, a storage component. Another piece is hand architecting templates for motions. Another piece is setting up the automation in terms of webhooks. Okay, well, when you get an update on your case, then these 5 things really need to happen so that you're kept abreast of everything that happens, including pulling the docket, pulling the document, doing an analysis, storing that, sending you the right emails. In terms of hallucination detection, then we just don't trust AI to put sites in. So whenever we have any output, we post-process it. We have regular expressions that determine, hey, look, this is what sites look like. We find them, we just delete them. Then we'll go and we'll ask that same context, hey, if you could do some research on this case, what would you want to research? We get a couple of queries. We just go to a regular lexical database. We run the queries. We get those sites. We get the link to those sites. Those are never touched by AI. We summarize the opinion. We have AI say, hey, look, where would you reinsert these arguments throughout the document that we post-process? It gives us arrays where it says, hey, look, this one should go here, this one should go here. And then we construct everything at the end just using traditional software, Python. We get your top caption, we prepare a Word document, we figure out what jurisdiction you're in, we format it, we string the arguments together, we reinsert the sites in there, put the summaries of the sites, hyperlink everything. And then you get something which maybe took 12 different steps and maybe 3 of them involved AI, but the output is really good. And you don't have to spend 2 hours trying to go and find every site and check them because they're hyperlinked. You just click on it. It takes you the opinion. Yeah, it's a real opinion. And we think that kind of cohesive, multi-dimensional approach is where law is going to go. Right now, I think people are still trying to grasp what the limitations of LLMs are. There's a lot of people that still haven't even played around with ChatGPT, especially in legal. So there's still some learning that legal needs to do. The early adopters are there. They're on the brink of everything. But having these multifaceted approaches is where I think legal tech is going to end up going.
That's a fantastic observation. There's a survey that went around recently looking at, how many people in law are actually trying AI? And a good number of people said that they had, but then when you dig into what they're actually using, most of them maybe just tried ChatGPT once and that was it. Most lawyers still have not tried dedicated legal AI tools. So I think you're right that in order to build the trust and the confidence that you're building a tool that's worthwhile, that is worth trying, it does have to take that multifaceted approach where it's not trying to automate the parts of the work that lawyers want to do, but again, it's looking at things like citations, looking at things like building trust, verifying outputs, and taking that multifaceted approach to how do we augment the workflows and automate the parts that people don't want to do, not the parts they do want to do.
Exactly.
So I have another question for you, kind of taking a step back. Legal tech vendors often fall into the trap of trying to be all things to all people. How do you serve different customer segments, identifying them, and then building unique features to serve each separate group's needs?
Yeah. Yeah, that's a really good insight. And that's one of the foundational theses here at Jurist AI is that we don't think just generalist catch-all solutions are helpful. And I think now we've reached a point where most people have realized that if they're going to use a generalist tool, they might as well just use ChatGPT, which itself is not really suitable for legal work and exposes you to a lot of liability. The tack that we take is that tools should be, number one, practice area aware, then number two, jurisdictionally aware. And the thing about making something that is practice area aware and jurisdictionally aware is that you really just can't rely on AI to do that. If you prompt an AI, oh, hey, yeah, just do it for this practice area and this jurisdiction, you're liable to get hallucinations or mistakes. It's the kind of thing that you have to hard code and design for in the beginning. So that's the tack that we took. The downside of doing this is that it takes a long time and it's very, very labor intensive and it's hard to do. And then you have to go back and forth with the customers. So it's difficult to jump on the hype train doing it that way, but you end up building something more robust. So our first tool was federal criminal specifically, one practice area, one jurisdiction. Our second tool is federal civil, so a couple of practice areas in one jurisdiction. But next year, as we move out into state, we want to delateralize that and have more specialized strains. So maybe some things can be grouped together because the motion practice is relatively similar, like employment discrimination or RICO cases. But when you get into doing personal injury law or divorce law or whatever other kind of litigation, just copy pasting the same things or having a generalist model that's just trying to mimic what it would be like in that particular practice area or jurisdiction, it gets you stuff that's subpar. You need something that is aware of, hey, I have a commercial litigation case in Alabama with this judge. How does this judge typically rule? What is the format of the documents? What's typical motion practice at the appellate level, for example, with Alabama specific case law that you can click the link that will take you to that case law. That's where you start getting something to where it really is providing a lot of value. But it just takes a very long time to do that. So that's been one of the major hurdles that we've had, is that since we do have that specificity, we can't necessarily let anybody use what we have right now until we build out to the use case. So I think probably the next area that we're really going to focus on is patent litigation, because there's a lot of opportunities to do a lot of automation on a mass scale. If one person has a patent, but they have 50 people infringing on it, then that's the kind of thing where attorneys will like to build an argument once and then just kind of have all the, yeah, it's for this specific defendant, that specific defendant, but the core argumentation is the same. So that's a good candidate for automation that we're looking at, which has a lot of federal crossover. But we're moving into state next year. And then one of the hurdles of state is just getting the data, right? So some states are really good with having the data. Some states are really not so good. So to answer your question at the beginning, practice area and jurisdiction specificity.
Yeah, and that's a really unique way of focusing your product. For one thing, lots of vendors are developing the same features or features that look very similar to one another, and typically trying to go as broad as they can, reach as many different people as they can. But there's this expression, the riches are in the niches. On one hand, I can see from a venture capital perspective, you want a bunch of different companies in your portfolio that are going as broad as possible so you can see which one's going to hit the home run. But if you're on the flip side of that, you're the lawyer looking at buying legal tech, you don't want to be the guinea pig for a bunch of startups, 9 out of 10 of which are basically designed to fail within the next several years. Instead, and I don't really think I've seen much of this, but I do wonder if we'll start to see more of this in legal tech as we hopefully bridge this cultural divide, because I do think that's where that insight comes from. Like you said, different practice areas in law are not the same. Different corporate practice areas are not the same. Different practices in litigation are not the same. Then you have areas like bankruptcy or real estate law, which are kind of their own beasts. And I think if you're coming to it from outside of law and not spending the time really embedding yourself with lawyers, you're not going to realize that. There are things you can scale up and there are things you can replicate. But to your point, at least if we're trying to provide value to lawyers and legal teams, I think there's more value in understanding how does this specific practice in this specific jurisdiction work. Because if you can understand that, you understand the actual craft that you're trying to augment, and then you can actually augment it in a useful way.
Yeah, exactly. And then the next level of specificity is the lawyer's specific writing style and the way that they approach motion practice, which is just another level of depth and nuance. Like you said, the riches are in the niches. So we do have a way to onboard their writing style currently. With motion practice, we haven't touched automating that quite yet. We are still having the lawyers sending email, let us know what motion that you'd like to generate a draft of or select it from a drop down. But we see that as the trinity of producing something that is specific enough to be useful. It needs to be in your area of the law, obviously with the right citations. It needs to be in your jurisdiction, and it needs to be aware of how you actually approach cases. When you have that, then it approximates something like hiring a human, which is kind of where we want to get to without replacing a lawyer, without dealing with the crux of the argumentation that they actually like to do, but with doing the parts that humans don't really like to do yet are forced to right now.
Yeah. All right, so now it's time for the Keeping It Human segment of the show. This is where I like to take a step back from all the legal tech and AI stuff and practice of law. The reason we're developing these solutions and using them is hopefully so we can augment the human side of things and spend more time looking at the critical thought and the creativity and the strategy that goes into it. And then hopefully having more time to go and spend on our own interests with our own families, that sort of thing after work. So keeping it human, what's your fun fact or anecdote for us today?
One fun fact, I'll give you a fun fact about myself since we're talking about automating things so we have more personal time. I'm really into tea, especially pu'er tea, and I can talk your ear off for a long time about that. But pu'er is a kind of tea that comes from only one province in China, Yunnan province, and it's a kind of dry fermented tea. So one thing that a lot of people don't know is that tea is kind of similar to wine in that all tea, if we're talking about actual tea, it comes from the same plant. But it's how much oxidization that happens to leaves after they're pulled out of the ground that makes it into green tea or into oolong tea or into black tea or into white tea. So I have storage in my house with just a whole bunch of, they come in cakes. They don't come in bags. They come in these hard pressed cakes. And some of them have been fermented for only a couple of months. Some of them were fermented for years. So I have like a little storage. So that's just a little fun fact about me that I'm really into tea. I really enjoy it. I think it's cool.
Nice. That's really cool. I'm not a tea purist. I drink one of those other things that isn't technically tea, but it's called tea. So my favorite is it's chai, but it's made with rooibos, the berry, instead of tea leaves. I just buy it in box tea bags, so nothing. I'm not sure if I can be called a connoisseur in the same way, but I do appreciate people who have a specific beverage that they like and they sort of curating a collection, it sounds like. But yeah, is that something where you think you might ever want to actually cultivate your own tea, or are you content to buy the good stuff from China?
I think that's just too hard. I think I'll buy this stuff. I would like to get into gardening maybe in the future if I had a lot of free time. But it seems like the process of cultivating the tea is pretty difficult. I look at people that roast their own coffee. And I'm like, man, that seems really hard. But the tea is a whole other level.
Yeah, I have no idea what goes into growing tea, let alone fermenting it properly.
Yep.
But that's pretty cool. I don't think I've met somebody who actually buys the tea cakes. I've met people buy loose leaf tea and they steep it that way, but that's new to me.
Well, if you're ever in DC, there's a really nice place that actually serves to where when I first saw the tea menu, I was shocked. I was like, oh my gosh, there's actually a tea nerd working here. So if you come down DC area, let me know. I'd love to take you out for a cup.
That's fantastic. So on that note, if people want to get in touch with you to talk about legal tech or possibly pu'er tea, how can they reach you?
You can just email me, ali@juristai.org, or you can go to juristai.org and you'll find the contact information there.
All right, ali@juristai.org. So fantastic. Ali, thank you very much for your time. I really enjoyed learning about what you're building and how you approach legal tech and building something of value for lawyers and legal teams. Don't be a stranger, everyone. Thank you for listening. It's great to have all of you with us today. Feel free to get in touch with Ali if you want to talk about Jurist AI, building legal tech, or tea. And feel free to get in touch with me at thelegaltechguide.com if you want to talk about all other things legal tech related. So thank you very much for your time. Have a great one. That's it for this episode of The Future of Law is Today. Subscribe for more straight talk on law and legal tech. And share it with someone who still thinks Master of Laws when you say LLM. Thanks for listening.